training. My name is John Ellem, and I'm the Deputy Commissioner, Deputy General Counsel. I'm not the Commissioner. I used to be a Commissioner on the Ethics Commission many years ago. And there we go. Maybe that's somebody that's coming in. One more to admit. And with me for the presentation today is Kateland Cantrell, our office paralegal. So this will fulfill your training for today.
I'll make sure they can see it. I'll make sure they can see that.
Let me make sure. Can everyone see my screen? Michael Height, can you raise your... I am not sharing then. My bad.
I can see the back of your screen if that helps.
Well, we don't want... We want a little more substance than that. How's that now?
I can see your screen.
It was up previously, but all right, now it's up.
Oh, there we go.
Now it's there.
Can see it now.
Okay. Is it all clear? Can you see it? Can you see it well?
Yes.
Yes.
I was in presenter mode. No, I just lost it. There we go. Okay, so the Ethics Commission is made up of 9 members appointed by the governor, of course, and then we have staff such as Kateland and I that oversee day-to-day operations of the Ethics Commission. All right, we forgot why that's not scrolling. So we'll begin by welcoming you to the WWE, the wonderful world of ethics, as I have it here. And I wanted to start out by explaining that ethics is more than about not getting into trouble. I think, among other things, understanding governmental ethics provides someone with confidence when you're working your hardest to serve your constituents and building trust through competence and dedication. Empowerment, leading to more efficient, effective work, and also for your citizens to feel that they are valuing their governmental institutions over personalities and parties. And then finally, humility, recognizing and appreciating the trust placed in you and embracing the responsibility of your role. A few more getting admitted.
I know Jonathan Kyle is still trying to make it in.
I have not seen him pop on. We'll try to get him a link.
Yeah, but he's also in Honduras right now, so he's on a different time. We had issues last night with our committee teams meeting on getting him in because he was on a different time zone.
Okay, well, I'll talk to him and maybe have to do it at another time. So the jurisdiction of the Ethics Commission constitutes at least 7 distinct categories. Number 1 is the West Virginia Ethics Act. Number 2 is school board eligibility. And then we also deal with a certain county code provision for county employees and officials. Provision for administrative law judges, lobbyist registration, financial disclosure, and of course the Open Meetings Act. The thing to remember about the Open Meetings Act is we do not enforce it. We can interpret the Open Meetings Act, but enforcement is left with the circuit courts. So primarily we're dealing with the West Virginia Ethics Act throughout this presentation, found in Chapter 6B of the Code. The Ethics Act itself, and we'll have hyperlinks throughout the presentation to different parts of the Ethics Act that I cite, so if you want a handy reference, you'll be able to do that. Some topics that we are going to include today, including the main topic, the use of your office for private gain, or the gain of someone else. Now, this is going to include things like nepotism, which we'll go over, in making endorsements, using the prestige of your office and dealing also with expenditures. We'll cover gifts. That's again part of that code provision I mentioned earlier. Interest in public contracts, a small little section on confidential information, employment restrictions, voting, and name likeness. Use of office for private gain. So this Hulu show illustrates probably one of your more extreme examples of using or taking public material and using them for your own private gain. What constitutes use of your office for private gain? And again, there's a hyperlink here to that primary code provision that governs the Ethics Act. You may not use your public position or your resources for your own benefit or to benefit another person. Now, the exception is the Ethics Act does require more than a de minimis use of your office for personal purposes. So here's actually an example of using a trash dumpster, of all things, for private gain. So if you are coming into work in your public job and you have an old fast food package in your from previous night's dinner in your car, and you take it into work and use your work receptacle, well, is that using your private office for public gain? I would argue that's probably de minimis. This example took it to the extreme and is why we always say the facts of each situation matter. Here, an elected clerk had used her office as a dumpster. And this included not just fast food bags, but a large amount of trash, such as roof shingles. They were using it during the weekend, and security cameras showed it wasn't just her, but it was her husband. And it was more than on one occasion that they were putting all of their garbage and apparently their old roof in the dumpster. Some other examples, and this really is the best way to understand using your office for private gain. A mayor had a town employee fix water leaks at his own personal residence. A state agency director stored personal furniture in a state's office building. A public service district employee sold PSD property or equipment on eBay, which pretty red flag there, and then kept the money in the process. So these violations resulted in essentially a conciliation agreement as a settlement agreement with the Ethics Commission. These are all real life examples. One involving cell phones. An agency may not allow its employees to use other than de minimis their agency provided cell phone as their personal cell phone unless the employees pay a reasonable fee. And this is applied even if it's an unlimited plan. So even if you do pay, the employee does pay part of the bill, you still cannot use that cell phone, that public cell phone, for commercial or political campaign use. The AO that's hyperlinked down here is a reference to our advisory opinions that the commission issues. And of course, stands for advisory opinion. The 2021 is the year the opinion was issued, and it was number 15 that year. This instance, actually, I understood pretty clearly where the agency was coming from. It was a health department who had certain employees that were required to carry a department-issued cell phone 24/7 to be available in the event of an emergency. And the agency wanted to be able to allow them to use that also for personal reasons, so that they would have the ability not have to carry two cell phones, that inconvenience. And the commission held that, the inconvenience of carrying these two cell phones was not enough, but again, that the employee could pay a reasonable fee to, getting a few more in, a reasonable fee to use the phone. This actually happened in 2001 when I was starting out in the legislature. This is before we had computers on the desk, so I guess I'm aging myself. But a couple of us had the need to, on occasion, to receive faxes. Couldn't get around it. We couldn't just totally abandon what was going on back home. We kept account of the pages that were faxed to us from our private offices and actually reimbursed the state. Another example, private office, use a public office for private gain. Can you, on state business, use a personal rewards card when purchasing fuel with a state credit card and keep the reward points for yourself? And the answer is yes, if it falls under what's known as the frequent traveler exception. This is an actual code provision that was added to 6B5 back in 2008. Before that time period, it would have been an issue. Since then, if you go look at that code provision and make sure you meet this definition, then you'll be okay. Property is not always involved in the use of the office for private gain. There is something known, or we refer to often as using the prestige of your office. In this matter, a circuit clerk had tried to convince a police officer who was arresting the clerk not to take him to jail. He told the officer, "You know, I'm the circuit clerk." He actually made threats to retaliate against the arresting officer. The sum result, he agreed to a settlement conciliation with the Ethics Commission. Another example, a prosecutor wanted to know if their boyfriend could serve as an assistant prosecutor. Now, we'll get into nepotism in a little bit, but they did not live together or have a financial relationship. But in this case, the prosecutor did not formally advertise the job opening, and the commission held that the requester's boyfriend had gotten an unfair advantage in being hired. So now we go into nepotism. A couple of key points to remember regarding nepotism. Another person admitted. First of all, the definition of nepotism contains the first key point I'd like to highlight. We often think of family members and relatives in terms of nepotism. And nepotism is defined here to show favoritism in employment or working conditions. That's the other thing to keep in mind. It's not just the hiring process, it's working conditions of relatives or persons with whom you reside with. So that's an important caveat to remember when considering nepotism. And then relative is fairly broadly defined to include spouse, mother, even your in-laws, and so forth. So with nepotism, a public official or an employee cannot directly supervise or participate in decisions affecting the employment or working conditions of his or her relative or a person with whom he or she resides. Now, there's a few very narrow exceptions, including whether there's an independent third party that's involved and basically intercedes or interjects between the supervision and the employee. If you have a nepotism issue, it's fleshed out a lot more in this legislative rule promulgated by the commission with the hyperlink there. I would point out that the definition of supervise is fairly broad, so you would want to look at that definition or give us a call to see if this applies to your situation. If you have a supervisory position over someone, then you have this more stricter standard, so to speak. So an example of this, a principal's wife, sister, and brother-in-law may be employed in the same school where he or she serves as the principal, but the principal may not be involved in hiring or supervising them. This is from an advisory opinion of 3 or 4 years ago, and seemed a little bit almost surprising to me till I went and reviewed this advisory opinion. And some of these relatives had actually worked at the school already when the principal came in. They weren't involved, obviously, in his hiring. And then it was also well established that the principal was not supervising any of these relatives in this instance. Some of the relatives had, a couple of them were teachers, and I think one was an assistant principal. And the assistant principal, I think, was supervised by somebody at the board, while the teachers had somebody else that were directly supervising them. So they did not run afoul of the nepotism provisions. Endorsements. So there is a prohibition against endorsing commercial products, such as listing your agency in some type of ad or other publication as a satisfied customer. You cannot send out a letter of support to other county clerks, for instance, for a specific product, even if it's meant to help. Now, you can discuss the vendor with those people who contact you and ask you questions about what you're using. In the case, for our purposes, for a legislator, legislators are, of course, part-time, and many of you have your own jobs apart from serving in the legislature, and you can continue, for instance, to be involved in commercials for your own business. Of course, you cannot use your public title in those commercials. Endorsements, again, using public office for private gain. This case involved a professor that was held not to be able, and again, it was an advisory opinion. He asked for an opinion, and the commission ruled that you cannot exclusively invite and allow one candidate to speak to a class at a public institution of higher education about, and it was crucial here in the opinion, about that person's platform, unless you give the other candidates in that same race the same opportunity. Now, if you don't have that political connection, then it's a different analysis. But if you are inviting a person to come to speak about what amounts to a political platform or political purposes, then you would have to give equal billing to other candidates. Unauthorized spending, we get occasional questions about this and some concerns about how public money is being spent. And we actually have, the commission has limited involvement in determining whether a proposed expenditure is okay. That's something that's essentially going to be a public policy matter, and things that are guide the determination or the West Virginia Code, legislative rules. You do want to keep in mind sometimes Attorney General opinions are relevant to the issue, as well as auditor opinions, and then you can always call and consult with your agency attorney. Paying for meals comes up every now and then. If you want to pay for meals for your employees, you look at the applicable laws to determine whether, first of all, your own agency's policy gives express or implied authority for the expenditure. If it's an unauthorized expenditure, it may violate the private gain provision of the Act. But that's in the case of if the purpose of the meal is really to benefit the employee or the official or someone else, and not to facilitate maybe the work of the government agency, say if you're working late at night or something like that. May a public agency use public funds to purchase things like coffee makers or refrigerators to office employees? Again, another advisory opinion going back quite a few years. That was held to be acceptable because the overriding benefit was to the agency and not to any specific employee, but to benefit the working conditions and thus benefit the agency. I think in my 6 or 7 months I've been with the commission now, I may have had one question regarding retirement events or parties. Doesn't come up too often. I've attached the link to the guideline here if it comes up in your case, but food, beverages, entertainments, and gifts and mementos are allowed. There are some expenditure limits for having these type of employee recognition or retirement events. If that comes up, you can again contact the commission, or you can take a look at the guideline, which is found on our website, and the link again is there. And similarly, you can spend up to $100 of public funds for the plaque itself or the commemorative item for the retiring employee. Again, for private gain, a county commission employee may be a candidate for and hold office on city council, but you cannot campaign while you're on the clock at your work. And that was, again, another advisory opinion. So solicitation and gifts can often be quite a few calls on solicitations and gift giving, and usually fairly surprisingly a lot of well-developed rules, but you can get fairly fact specific in each instance. Solicitation of gifts is generally prohibited by somebody in office or the employee, and you don't accept a gift with a fair market of value of over $25 if you have somebody who is an interested party. This is paragraph C of the Ethics Act, again, the hyperlink. Now, what is an interested party? That's defined in the code. Interested party, of course, includes a lobbyist or anybody who meets any of these three conditions. So if they're seeking to do business with the agency, the public agency, if they're regulated or controlled by the agency, or there's some specific financial interest that could be affected by the performance or the non-performance even of any official duties. So lobbyist or interested party kicks in the gift rules. Now there are exceptions. Exceptions to the gift rules include meals and beverages. Some of you may be familiar with this, that it does require the person purchasing the meal to be present. Any ceremonial gifts, though, that are of an insignificant value, such as a plaque, are an exception, as well as items that are purely private in nature. And the guideline is one more admission. The guideline is on our website and hyperlinked here. Educational seminars, this doesn't come up a whole lot, but this is acceptable to be invited. You can accept a reduced rate or have a third party pay for it going to an educational seminar, but there's a 5-part test that we go through that's established by rule to see if the ultimate benefit is to the agency. And then there is a prohibition in the rule against having this third party pay for a cost of a guest, such as your spouse or children. So that's really a fact specific inquiry using that 5-part test. That's something I would recommend if you get into that issue to look at, and even you would want to give us a call to help you. Being a panelist or speaker, you can accept travel, food, and lodging. You can also accept costs for one guest, but the overnight stay must be based on a business necessity. Again, the guidelines that we publish and put on our website is helpful in that regard. Public servants may only accept items from an interested person valued at $25 in a calendar year. Now, if it goes above that, you do have the option of returning it, donating it to charity, or donating it to the agency. And things do not go both ways. So a public servant may not solicit a lobbyist for food, beverages, or other gifts. Important reminder. Charitable rules. Charitable solicitations still governed under paragraph C on gifts. And a gift can only be solicited for a charitable purpose, such as the United Way. Public agencies can impose stricter standards, and again, we follow the rules for solicitation. Key caveat here is a supervisor may not solicit contributions from a subordinate. This is a legislative exception that's set forth in the code provision down here, where you can get joint approval of the Joint Committee on Government and Finance, where a legislator can solicit donations for certain meetings, and then there's certain prerequisites right here that come into play. For instance, meetings that are facilitating cooperation between state legislators. So that's again a fact-specific inquiry and directly provided for in code, and the process for approvals by the Joint Committee is provided for in code. So a couple questions. May a state legislator accept a door prize of 2 round-trip airline tickets that he won at a reception to which many other legislators were also invited? Although the reception was open to the public, the legislator attended in his official capacity, and in this advisory opinion, he could not accept the round-trip airline tickets. Public contracts, D, under subparagraph D under the Ethics Act. Public servant cannot have a financial interest in a public contract under their direct authority or control. The exceptions are key for purposes of this presentation. Now there's a $1,000 threshold, but in particular highlighted here in red, part-time appointed officials and legislators are not subject to this prohibition. Of course, you still have to recuse yourself if a conflict arises in the public employment exception. The Ethics Commission also, in the case of where it does apply, we do have discretion to grant an exemption to a public entity based on hardship or excessive cost. An important exemption, especially for a state like ours, where we have many small communities, and it's just a county commission or municipality, for instance, may need to contract for some work, and there just simply may not be many providers that can offer the service, and they have to go with someone that would otherwise constitute a violation of the act. You can contact the commission in that case, and if you meet the hardship standards, then you could get an exemption to this prohibition of using public office for private gain. Important exemption, especially again for a small state. This is something that I think is relatively unknown, so I have included it in my presentation, probably more so for people that are employees or managing employees. We do have a confidentiality provision under the Ethics Act. Again, we're still dealing with 6B25. Now we're under subparagraph E. And this, you'll note right away, applies to present or former officials and employees, and prohibits the disclosure of confidential information or using that information to further your own interest or the interest of another person. This can result even in criminal prosecutions and employment restrictions. Looking for a job. So a full-time public official, employee or officials may not seek employment with or buy, sell, or lease property to any person who they had a matter on which they or a subordinate took regulatory action within the previous 12 months, or if there's a matter currently pending before the agency on which they are subordinate or working on, or you can have employment with a vendor over which you exercise control. Again, the key highlighted in red is full-time. So again, in the case of a legislator, this provision does not apply since legislators are part-time. This is 2 advisory opinions that have interpreted the same provision under the Ethics Act. Could a legislator also serve as the recorder for a city? So I tried to highlight both advisory opinions because the later one, 2023-09, modified this earlier opinion somewhat. A legislator, if you look at the Constitution as discussed in 2012, a legislator may not be employed by the state or hold a lucrative public office. However, the Ethics Commission itself has no jurisdiction over whether this is constitutionally allowed. There is something also to look at called the doctrine of incompatibility, but this is by virtue of the Attorney General's office. So the doctrine of incompatibility says the inconsistent nature of offices can render it impossible to perform duties of both. Again, that goes back to an AG opinion and also to state employees holding public office. So this provision, this advisory opinion, excuse me, was modified just the year before last, saying that while our Ethics Act prohibits public officials from using public positions to benefit private businesses or entities that may be nonprofit that employ them, it does not prohibit public employees or officials from using their position to benefit their employer, because a public employer or public agency is not a person for purposes of the private gain restrictions. So benefiting your public agency, then it's taken outside of the context of Advisory Opinion 2012. That's a mouthful. And again, always happy to answer any questions for people that call in to the Ethics Commission. Employment exemptions. In this case, an employee who oversaw work of a private contractor for repairing some projects at the Capitol. The owner of the company mentions that someone was retiring. He tells the employee he'd be a perfect fit to replace the person. May the state employee meet with this person for lunch to discuss this job opportunity. Again, this comes down to how to obtain an employment exemption. You would want to contact the commission for purposes of obtaining an exemption and look at code provisions F, G, and H. Separately, though, are post-employment restrictions involving what we call the lobbyist revolving door. I think that was enacted back in 04 or 05, 2004, 2005. Legislators and will and pleasure professional employees of the legislature that are under the direct supervision of a legislator may not, during or up to 1 year after you leave office or terminate your employment, register as a lobbyist. Again, key here is legislators and employees that are under the direct supervision of a legislator. So for other employees, you probably would go ahead and want to call the commission anyway to see whether this prohibition, the 1 year revolving door ban, applies to you. Voting. Of course, we have House Rule 49. When a question is put, a member that has an interest, as many of you know, you make a request to the chair or the speaker to be recused from voting, and you can be recused unless it affects you as a member of a class. I know in my time, I think I recall one time in 14 years where I have seen somebody recused from voting, and it was a delegate. We were considering a bill authorizing payments by the Court of Claims, and lo and behold, one of the payments among a series of payments in the bill was a payment to a actual legislator who asked himself to be recused, and he was recused. But quite often the class exception comes into play. Very important exception too. And then I won't repeat the whole Senate voting rule, but we have Senate voting rule number 43 here. Now, if you do ask to be excused from voting or made an inquiry about whether you should be excused, and the presiding officer requires you to vote, then if it's later alleged to be wrong, you cannot be found guilty of violating the Ethics Act. That's your insurance provision. Public officials may not vote if they are an immediate family member or a business with which they or a family member is associated with have a financial interest. Again, there's a class exception, and public officials may not vote on a personal matter involving a relative. If a member serves on a nonprofit, the agency may still make appropriations to the nonprofit. You look at code subparagraph J. However, the member or spouse may not vote if either is employed by the nonprofit. We get a few questions on this because a lot of people do serve on boards. If a board member is unpaid, he or she may vote, but only if disclosed on the agenda and at the meeting. Okay, so name, likeness, trinkets. I think this goes back 6 or 7 years. No one's ever named a building after me. I tried to, on a trip, to get that changed, but it's still the Taj Mahal. And I quickly changed my mind when I learned that the Taj Mahal is actually a mausoleum to this emperor's deceased wife. So anyway, as an aside, if you ever get a chance to go to India, it's beautiful, and the marble kind of reminds me of the marble at our own very beautiful state capital. But as of a few years ago, the law prohibits state, county, municipal entities from dedicating or naming a public building or a structure for someone currently holding office. You cannot use public funds or public resources to display your name for or likeness if you're trying to if it's promoting your public official or political party. But you may use your title, of course, in the normal course of business, letterhead, envelopes, educational reports, and so forth. Name or likeness limitations. Again, I think probably somewhat commonsensical. A town employee may not display a cup that contains a campaign slogan at work. The use of public resources to promote a political party is a violation or potential violation of the Ethics Act. Another advisory opinion addressing this. Before we get to questions, a few miscellaneous items that may be of interest or relevant to you under the Ethics Act. We do require, a lot of people don't know, but we do require state agency contracts of $1 million or more. The state agency files a disclosure of the interested parties in that contract on a form with the commission. You'll see a picture of our website shortly, and these can be viewed by going to the left side of our website, and you'll see a tab for agency contracts. One thing to keep in mind, we do have a special code provision on school boards. Every time I get a question on it, which hasn't been too often, I have to go back and look at this provision. But a Board of Education member has quite a few prohibitions under this code provision. They cannot hold or even run for any other public office unless that other office is uncompensated and unrelated to public schools. Financial disclosure statements, something everyone's going through now, and we're certainly in the middle of all of that, helping people. Elected and various appointed officials in state government file these by February 1st on an annual basis. The form I think is fairly self-explanatory with all the different categories: employment, contracts and investments, etc. And these statements are public matters of public record. They do not need to be filed or not filed by employees of the legislature. And then the topic that we really don't, we take no pleasure in dealing with complaints, but we do, that is part of our jurisdiction. Complaints can be filed by anyone as long as they are verified. Complaint forms are available on the website or they can be mailed to you. And we have a statute of limitations of 5 years on filing complaints. That 15, 16, 17 years ago, I think that was maybe we had a 2-year statute of limitations, and that was later changed to 5 years. The Ethics Commission can initiate a complaint on its own if we have credible evidence. Complaints must show a violation of the Ethics Act. So, we receive complaints for civil rights violations and things of those nature, which are, of course, are not under our jurisdiction. And then for procedure, if an investigation reveals there's probable cause, then a statement of charges is issued and the matter does become public at that point and proceeds on to a hearing. At any time in the process of a complaint, the Ethics Commission can enter into what's called a conciliation agreement, essentially a settlement agreement that avoids having this public hearing and incurring the related expenses, which is, I would say, I don't want to say it's a benefit, but if you look at some of the sanctions, one of the sanctions includes reimbursing the commission for cost of the investigation. And it's quite often the case where the cost that's required to be reimbursed if someone goes through the whole process is much higher than the fine itself. But that's one of the sanctions that can be included under the Act or provided for under the Act, including also a public reprimand. The fine can be quite hefty. It can go up to $5,000 per violation. And in extreme cases, a recommendation can be made to respondent to the complaint is terminated from office or employment. So speaking of advisory opinions, which I cited quite heavily, advisory opinions, you can see are on you can access them through the left side of our website. There are quite a few advisory opinions, but if you go to the index, you can search by topic matter. Advisory opinions are issued by the Commission. They are discussed and approved in a public meeting. And we do keep the person requesting the advisory opinion, their identity, confidential. And the good thing about an advisory opinion, if you rely on one or call us and we cite an advisory opinion to you, and you rely on that opinion in good faith, then you have immunity for that conduct in being prosecuted under the Act. So probably one of the most important pages, there's our phone number, our contact information. You're welcome to call with questions under the Act or the Open Meetings Act or other areas that we cover during our business hours. We're happy to answer those questions, and I would say that pretty much that is a significant amount of what we do. The public and others, state officials, state employees don't see that part of our job, but we get a lot of calls. We're happy to address those, and you can almost kind of think of it as, your own sort of insurance policy, a benefit to you to call us and give us your question under the Act. If we can't answer it on the phone right then and there, we'll certainly research it and give you a memo or a call back to answer your question. So I think I will go ahead and stop presenting. Anybody have any questions in the last few minutes? Let me see if I can. Oops. Go ahead. Is there anything in the chats?
Delegate Cumpier.
Okay, I thought I saw it was you. Go ahead.
It's just a housekeeping concerning question. I noticed for some reason I'm on the video, but my name is not available. I just want to make sure that I was on record as being participant.
You know, I appreciate you reminding me of that, actually. We are taking a membership list down, but sometimes instead of names, we just get phone numbers. So if you could all email the commission to confirm your attendance, we'll make sure to note that you attended at the meeting. Just send an email saying you were present. Thank you for reminding me. But she's also wrote your name down right now too.
Okay, thank you.
Anybody else have any questions?
Do you want us to send that email to the ethics@wv.gov?
You can send it there, or if you go to the website, you can access our contact information individually there too, under staff on the left side near the top. Let me see if I can go back to present. Go ahead.
This is Sarah Drennan. I know we have an ethics report that's due on the 1st. Is this pertinent or similar to that, or is that something completely separate?
Are you talking about the financial disclosure? Is that what
I think so, yes.
Yeah, that's what I had just discussed earlier.
Okay.
That form we got about a week left before that form is due.
Okay.
And we're also working on a portal that'll be, I think, especially beneficial to lobbyists filing their reports that they do 3 times annually. But we don't know if that'll include financial disclosure statements yet or not, do we?
I don't think so. I think the financial disclosure is separate here.
And then
the link for that is on the website. If you previously have filed on there, you should be able to get on there with no issues.
yeah, the portal itself that is underway is having technical issues. So we're working with the software developer to get through those, but hopefully that'll save on a lot of paperwork here in the future. I think we still have a few more minutes. Again, there's the email addresses. Let me see. Everybody's seeing the website come up? Are you all able to see the website? Okay, thank you.
Yes.
The website, do a quick highlight of it. All the relevant links are over on the left side. If you go to About Us, you can click on staff and you can email your name to me or Caitlin or both of us to confirm your attendance here. The advisory opinions are under this tab. And again, they're very easily accessible, including by topic matter, whether it's gifts, contracts, private gain issues. But the one I wanted to highlight in particular for you, since we're here, and of course, if you want to look at any statutes or rules, they're all under statutes and rules. In particular, get there. Title 58, if you're looking at nepotism, like I mentioned earlier, it's a lot of nepotism is provided for in the rules, so you can click on and link the rule on to the rule on nepotism there. But another thing that you may find very valuable from our website is this tab here, forms, booklets, and guidelines. And we have 16 different booklets and guidelines, including on the Ethics Act itself. And then we talked about revolving door. So there's a difference between an employment exemption and the revolving door prohibition, and that topic is itself dealt with in its own guideline, and there's also some guidelines for gifts and so forth. So if you have anything to look up, I was really surprised when I started just how thorough that was. Yes, sir. I hope I opened you up there. Is that Mr. Leslie?
Yes, I was just double checking that we can get CLE credits for this.
I am not positive on that. I'll have to get back to you. Shoot me an email, please.
Will do.
I remember seeing that being available for other presentations, but I will double check that for you. So again, thank you all for attending, and we look forward to being able to help you. If you have any questions, don't hesitate to shoot us an email or give us a call. It's one of the benefits of being in public service, and also thank you for your public service too. So with that being it, I'll go ahead and we're going to conclude 5 minutes early. Thank you, everyone.
Thank you.
Thank you, John.
Thank
You have a good day.
Thanks.